We go now to Chapter 5 of the Revised Penal Code, Alternative Circumstances. Alternative circumstances refer to circumstances wherein they may be appreciated as an aggravating circumstance or a mitigating circumstance depending on the conditions involved. The concept of alternative circumstances in the Revised Penal Code is discussed in Article 15. It states that alternative circumstances are those which must be taken into consideration as aggravating or mitigating according to the nature and effects of the crime and other conditions attending its commission. They are the relationship, intoxication, and the degree of instruction and education of the offender.
The alternative circumstances of relationship shall be taken into consideration when the offended party is the spouse, ascendant, descendant, legitimate, natural, or adopted brother or sister, relative by affinity in the same degree of the offender, stepfather, stepmother, stepson, or stepdaughter, adoptive parent, and adopted child. The reason for considering the relationship of stepfather or stepmother and stepson or stepdaughter is that it is the duty of the stepmother to bestow upon her stepdaughter a mother's affection, care, and protection. Hence, the effect of the crime of murder committed by the stepmother against her stepdaughter makes the relationship aggravating. But the relationship between uncle and niece is not covered by any of the relationships mentioned. Appreciation of relationship. As a rule, relationship is mitigating in crimes against property by analogy to the provision of Article 332 of the Revised Penal Code, the crimes of robbery, usurpation, fraudulent insolvency, and arson. For crimes against persons, when the offense committed is less serious physical injuries or slight physical injuries, and the offended party is a relative of a lower degree. In case of infanticide and abortion, the killing or abortion to conceal dishonor, and the concealment made by the maternal grandparents is a mitigating circumstance. When relationship is exempting. In the case of an accessory who is related to the principal within the relationship prescribed in Article 20 of the Revised Penal Code. In Article 247 of the Revised Penal Code, a spouse will not incur criminal liability if less serious physical injuries or slight physical injuries was inflicted after having surprised his or her spouse or paramour or mistress committing actual sexual intercourse. The same shall apply to parents with respect to their daughter under 18 years of age and their seducer while the daughter is living with their parents. In view of the provision of Article 332 of the Revised Penal Code, in the crime of theft, malicious mischief, and swindling or estafa, there is no criminal liability if the offender is related to the offended party as spouse, ascendant or descendant, or relatives by affinity in the same line. Stepfather and stepmother are included as ascendants by affinity. The widowed spouse, with respect to the property which belonged to the deceased spouse before the same passed into the possession of another. If the offender is a brother or sister or brother-in-law or sister-in-law of the offended party and they are living together. Note that Article 332 is exclusive. Hence, if the crime is robbery or estafa through falsification, this article does not apply. If the son committed estafa through falsification of a commercial document against his father, he is criminally liable for the crime of falsification. The exemption does not include strangers who cooperate in the commission of the crime. When relationship is considered as aggravating. In crimes against persons, where the offended party is a relative of a higher degree than the offender. When the offender and the offended party are relatives of the same degree, such as killing a brother, brother-in-law, a half-brother, or adopted brother. In case of murder or homicide, if the act resulted in the death of the victim, even if the accused is a relative of the lower degree, and in a crime of rape, such as when a stepfather raped his stepdaughter or when a father raped his own daughter. If the crime against persons is any of the serious physical injuries, the fact that the offended party is a descendant of the offender is not mitigating. For serious physical injuries, even if the offended party is a descendant of the offender, except when committed by the parent who shall inflict physical injuries to his child due to excessive chastisement. For less serious physical injuries or slight physical injuries, if the offended party is a relative of the higher degree of the offender. For crimes against chastity, in acts of lasciviousness, relationship is always aggravating regardless of whether the offender is a relative of a higher or lower degree of the offended party. The reason behind is that because of the nature and effect of the crime committed, it is considered aggravating, although the offended party is a relative of lower degree. It is not shocking to our moral sense when we hear a father committed, for instance, the crime of slight physical injury against his daughter, but it certainly is very shocking when we hear that a father committed acts of lasciviousness on the person of his own daughter. The rule may be different because of the other condition attending the commission of the crime. While the relationship of brothers-in-law is aggravating, when one commits a crime against the other, such relationship is mitigating when the accused killed his brother-in-law in view of the conduct pursued by the latter in contracting adulterous relations with the wife of the accused. Also, in a case where the deceased was suffering from an attack of insanity and the accused, his brother-in-law, in his desire to place the deceased under control, struck him with a club exceeding the limits of his discretion in the heat of the struggle, it was held that relationship was mitigating because the cause of the maltreatment was a desire to render service to a relative.
The second alternative circumstance under Article 15 of the Revised Penal Code is intoxication. There is intoxication when the offender has taken such amount of liquor of sufficient quantity as to affect his mental capacity to determine the consequences of his act. Intoxication can be mitigating and aggravating. Intoxication is considered as a mitigating circumstance if it is not habitual or subsequent to the plan to commit the felony. The reason for this alternative circumstance is in the fact that when a person is under the influence of liquor, his exercise of willpower is impaired. Intoxication is considered as an aggravating circumstance if it is habitual and it is done subsequent to the commission of a felony. The reason for this is it is intentional. The offender resorted to it in order to bolster his courage to commit a crime. For example, Nico wanted to commit a felony. Since he had no courage, he deliberately takes liquor as a stimulant for him to commit the felony.
In the previous discussions, we have learned that alternative circumstances are those which must be taken into consideration as aggravating or mitigating according to the nature and effects of the crime. The third alternative circumstance is the degree of instruction and education of the offender. Note that if there is a low degree of instruction and education or lack of it, it is generally mitigating. High degree of instruction and education is aggravating when the offender avails himself of his learning in committing the crime. First, we need to tackle about lack of instruction as mitigating. In the case of People versus Mangsan, lack of instruction cannot be taken into account when the defendant admitted that he studied in the first grade in a public elementary school. Article 15 applies only to him who really has not received any instruction. So in this case, it is clear that lack of instruction as alternative circumstance can be applied if the accused has not received any instruction at all, meaning he did not receive education even in grade 1. However, if he received instruction for as little as grade 1, the benefits of Article 15 will not be applied to him. On the other hand, lack of instruction must be proved by the defense. The burden of proving there is a lack of instruction rests with the accused and his counsel. As mitigating circumstance, lack of instruction must be proved positively and directly and cannot be based on mere deduction or inference. This means that lack of instruction cannot be based on hearsay or allegation. It must be based or proven by evidence. As for the instances when lack of instruction is raised during appeal, a decided case specifically mandates that the question of lack of instruction cannot be raised for the first time in the appellate court. As a rule, it is for the trial court rather than the appellate court to find and consider for the circumstance of lack of instruction. In addition thereof, low degree or lack of instruction is mitigating in all crimes. Exception of this rule is that it is not mitigating in crimes against property such as estafa, theft, robbery, arson, and crimes against chastity such as rape and adultery. It is also not mitigating in treason because love of country should be a natural feeling of every citizen, however unlettered or uncultured he may be. However, exception to this exception, in U.S. v. Mackey, lack of instruction was mitigating in theft of large cattle committed by a member of an uncivilized tribe of Igorots or in Igorot land. As application of the rule that low degree or lack of instruction is mitigating, in People v. Patricio, a case with robbery with homicide, where the accused was illiterate, lack of instruction was held to be mitigating. We go now with the discussion of lack of education and instruction with the crime of murder. In cases of murder, it was held in People v. Mutia, lack of education and instruction cannot mitigate appellant's guilt because to kill is forbidden by natural law, which every human rational being is endowed to know and feel. We have learned in the previous discussion that a low degree of instruction and education or lack of it is generally mitigating. High degree of instruction and education is aggravating when the offender avails himself of his learning in committing the crime. We now focus with the aspect of high degree of instruction and education. A concrete example of this is when a doctor, who using his knowledge prepared certain kind of poison to kill his victim in such a way as to avoid detection, may be considered as having taken advantage of his high degree of instruction and education. However, not because an accused has a high degree of instruction and education, this law automatically applies to him. He must avail of his learning in order to commit the crime. Hence, in People v. Solit, where a lawyer was charged with the crime of physical injuries, the court held that the alternative circumstance of high degree of education or instruction is not applicable since he did not use his knowledge of being a lawyer to hurt the victim. However, if Solit used his knowledge of the law in committing the crime, like hiring another person to induce physical injuries so that he may not be implicated as principal, this alternative circumstance will apply to him.
Now let's look into 3 Supreme Court decisions that interpreted how alternative circumstances are applied to actual cases. Let's start with People v. Mendico, GR number 167954, January 31, 2008. This is a case of how Perlita Mendico was charged with murder and frustrated murder which sprung from a morning drinking spree he had with Damaso's son Delphine, and 3 other unidentified individuals. They were later joined by Damaso's other son Anthony at around noon. But around 6 p.m., Mendigo suddenly hacked Anthony with a jungle bolo and then attacked Damaso, who unfortunately died from the injuries he sustained. Mendigo invoked self-defense, but the trial court found him guilty of murder for the killing of Damaso and serious physical injuries for the hacking of Anthony, mitigated by intoxication. The Court of Appeals affirmed the trial court's ruling with the modification that the appellant was liable for frustrated murder for the hacking of Anthony. The Supreme Court affirmed the Court of Appeals decision with the modification that Mendigo is found guilty of homicide for the killing of Damaso. With regards to the mitigating circumstance of intoxication decided by the trial court, the Supreme Court said that the trial court erred in crediting appellant with the circumstance of intoxication as having mitigated his crimes because the stabbing incident ensued in the course of a drinking spree. For the alternative circumstance of intoxication to be treated as a mitigating circumstance, the defense must show that the intoxication is not habitual, not subsequent to a plan to commit a felony, and the accused's drunkenness affected his mental faculties. Here, the only proof on record on this matter is appellant's testimony that before Damaso, Anthony, and Delphine attacked him, he drank about 3 to 4 bottles of beer. The low alcohol content of beer, the quantity of such liquor appellant imbibed, and the absence of any independent proof that appellant's alcohol intake affected his mental faculties all negate the finding that appellant was intoxicated enough at the time he committed the crimes to mitigate his liability. Now, let's go to the second case. People versus Sichon, GR number 134362, February 27, 2002. Emilito Sichon was convicted of murder and sentenced to death by the Regional Trial Court of Manila for beating to death by using a steel hammer and wooden stick the 2-year-old son of his common-law wife. Sichon said the killing of the boy was accidental. He reiterated that he was under the influence of drugs, which he had taken one after the other. He was a drug dependent and, in fact, had been confined at the Tagaytay Rehabilitation Center. He said he was conscious when the incident happened, but he simply did not realize that he had hit the child hard with the broom's wooden handle. He denied having hit the boy with a hammer or having banged his head against the wall. He hoped the trial court would be lenient with him because of his voluntary surrender. The court found the accused guilty beyond reasonable doubt for the crime of murder. But as to the trial court's consideration of intoxication as an aggravating circumstance, the Supreme Court didn't agree. The Solicitor General defends his ruling, contending that the appellant's habitual drug addiction is an alternative circumstance analogous to habitual intoxication under Article 15 of the Revised Penal Code. Intoxication of the offender shall be taken into consideration as a mitigating circumstance when the offender has committed a felony in a state of intoxication, if the same is not habitual or subsequent to the plan to commit said felony. But when the intoxication is habitual or intentional, it shall be considered as an aggravating circumstance. The court does not agree. Article 13 of the Revised Penal Code provides a list of mitigating circumstances which work to reduce the account's penalty. Article 13(10) allows courts to consider any other circumstance of a similar nature and analogous to those mentioned therein. Neither Article 14 of the same code on aggravating circumstances nor Article 15 on alternative circumstances, however, contain a provision similar to Article 1310. Accordingly, the court cannot consider the appellant's drug addiction as an aggravating circumstance. Criminal statutes are to be strictly construed, and no person should be brought within their terms who is not clearly within them. Now, finally, let's go to People versus Makatanda, GR number L51368, November 6, 1981. Makatanda was guilty beyond reasonable doubt of the crime of cattle rustling, penalized under Presidential Decree number 533. From the judgment of conviction, Makatanda appealed direct to this court, saying that his lack of instruction and education and his being a Muslim belonging to a cultural minority should mitigate his liability, and the penalty imposed by the trial court should be reduced accordingly, to which the court refused. According to the court, in any case, mere membership in a cultural minority is not expressly mentioned by the revised penal code among the mitigating circumstances, nor would it come under paragraph 10, article 3 of the said code, which speaks of any other circumstances of a similar nature and analogous to those above mentioned. Appellant, however, praised for a lenient approach in consideration of his being an ignorant and semi-uncivilized offender belonging to a cultural minority, the two separate circumstances to be joined together to constitute the alternative circumstance of lack of instruction to mitigate his liability. The court said that membership in a cultural minority does not per se imply being uncivilized or semi-uncivilized state of the offender, which is the circumstance that induced the Supreme Court in the Maki case to apply a lack of instruction to the appellant therein, who was charged also with theft of large cattle. Incidentally, the Maki case is the only case where lack of instruction was considered to mitigate liability for theft, for even long before it, in U.S. v. Pascual, a 1908 case, lack of instruction was already held not applicable to crimes of theft or robbery. The Maki case was decided in 1914, when the state of civilization of the Igorots has not advanced as it had in reaching its present state since recent years, when it certainly can no longer be said of any member of a cultural minority in the country that he is uncivilized or semi-uncivilized.
Here's another sample problem. Mario was invited to a drinking spree by friends. After having a drink too many, Mario and Luigi had a heated argument, during which Mario stabbed Luigi. As a result, Luigi suffered serious physical injuries. Question: may the intoxication of Mario be considered aggravating or mitigating? Answer: the intoxication of Mario may be considered mitigating since it was merely incidental to the commission of the crime. The law provides that the intoxication of the offender shall be taken into consideration as a mitigating circumstance when the offender has committed a felony in a state of intoxication, if the same is not habitual or subsequent to the plan to commit said felony. In the case at bar, there was no clear indication that the intoxication of Mario was habitual or intentional. Therefore, it shall be considered as mitigating.
Now let's proceed to sample problem number 2. In 1996, Canor, a 30-year-old laborer, through force and intimidation, had sexual intercourse with his younger sister, Caitlin, who is only 16 years of age. It was revealed that the accused ejaculated twice inside his sister. The prosecution charged Canor for the crime of rape with the alternative circumstance of relationship, to be appreciated as an aggravating circumstance. The defense contends that Kanor's crime should be mitigated instead, since he had a lack of degree of instruction and education, claiming that Kanor did not even finish grade 2 in his elementary school. The question is, given that the defense statement is true, should the crime be mitigated or aggravated due to the alternative circumstance in this case? Suggested answer: the crime should be aggravated and not mitigated. Under Article 15 of the Revised Penal Code, a crime committed against relatives of the same degree shall be appreciated as an aggravating circumstance. Included in the same article, the lack of degree of instruction and education shall be mitigating in all cases, only if the accused has not received any instruction or education at all. In the present case, Kanor and Caitlin are relatives in the same degree. Moreover, the fact that Kanor did not finish grade 2 shall not mitigate the crime because the requirement is that the accused must have no instruction or education at all, not even graduated grade 1 education, which Kanor did in this case. Therefore, the crime should be aggravated and not mitigated. Thank you for watching and listening to our discussion in Article 15 of the Revised Penal Code, the Alternative Circumstances. We hope you have learned and enjoyed your time with us. Good luck to each one of us in our law school journey, and God bless in the bar.